we shall talk about the often heard fortuitous event or acts of God as a defense. If pawned jewelry was lost because of robbery, is the pawn shop liable for such loss? Let's take a peek at Lulu's problem. Lulu pawned several pieces of jewelry with Agencia de Roberto to secure a loan worth 60,000 pesos. After a month, two armed men entered the pawn shop and tied the pawn shop owner, Roberto, with an electric wire and ordered Roberto's assistants to lie face down flat on the floor while they took away whatever cash and jewelry found inside the pawn shop vault. Roberto sent Lulu a letter informing her of the loss of her jewelry due to the robbery incident in the pawn shop. Lulu wrote a letter to Roberto expressing disbelief, stating that when the robbery happened, all jewelry pawned were supposed to be deposited with the bank near the pawn shop, since it had been the practice that before they could withdraw, advance notice must be given to the pawn shop so it could withdraw the jewelry from the bank. Lulu then requested Roberto to prepare the pawned jewelry for withdrawal, but Roberto failed to return the jewelry. Lulu filed a complaint against Roberto in court for the loss of the pawned jewelry and payment of actual, moral, and exemplary damages, as well as attorney's fees. For his defense, Roberto insists that he is not liable since robbery is a fortuitous event and he is not negligent at all. Is the contention of Roberto tenable? Is robbery a fortuitous event? The Supreme Court ruled in a similar case that fortuitous events by definition are extraordinary events not foreseeable or avoidable. It is therefore not enough that the event should not have been foreseen or anticipated as is commonly believed, but it must be one impossible to foresee or to avoid. The mere difficulty to foresee the happening is not impossibility to foresee the same. To constitute a fortuitous event, the following elements must occur. The cause of the unforeseen and unexpected occurrence or the failure of the debtor to comply with the obligations must be independent of human will. Number two, it must be impossible to foresee the event that constitutes the caso fortuito, or if it can be foreseen, it must be impossible to avoid. Third, the occurrence must be such as to render it impossible for the debtor to fulfill obligations in a normal manner. And fourth, the obligor must be free from any participation in the aggravation of the injury or loss. The burden of proving that the loss was due to a fortuitous event rests on him who invokes it. And in order for a fortuitous event to exempt one from liability, it is necessary that one has committed no negligence or misconduct that may have occasioned the loss. It had been held that an act of God cannot be invoked to protect a person who has failed to take steps to forestall the possible adverse consequences of such a loss. One's negligence may have concurred with an act of God in producing damage and injury to another. Nonetheless, showing that the immediate or proximate cause of the damage or injury was a fortuitous event would not exempt one from liability. When the effect is found to be partly the result of a person's participation, whether by active intervention, neglect, or failure to act, the whole occurrence is humanized and removed from the rules applicable to acts of God. The pawn shop has a security guard, and the pawned jewelry were stored in a vault. The very measures which Roberto had adopted clearly shows that to him, the possibility of robbery was not only foreseeable, but actually foreseen and anticipated. We hope that we were able to give you an educational evening in the field of law. If you have any questions regarding your legal concerns that are not yet pending before the courts, please do not hesitate to email us at ptv4newscenter@gmail.com. This has been Attorney J.J. Jimeno Atienza for the Rule of Law.